Good morning. This is call number 2021-18021 in the interest of Stephanie Spikes McClendon. All parties and witnesses, please raise your right hands to be sworn and unmute yourselves.
Miss Spike, that's you.
Ms. Spikes, I can't see you. Ms. Spikes, are you there?
Judge, I don't know where she went away. She was just here. Do you want us to step down and?
There she is. There she is.
Okay,
All right.
it was great. Okay.
All right, Ms. Spikes, raise your right hand to be sworn. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, please state your name and your relationship to the child.
Patricia Spikes, and that's my daughter.
All right, and representing the state.
Kavita Sharma, Your Honor.
Court will note that the non-custodial parent is Sterling Anthony McClendon Jr. Mr. McClendon was personally served on September 28, 2021 at 12:24 p.m. at 9009 Lockwood Drive in Houston, Harris County, Texas. And he's not filed an answer or made an appearance. Is that correct, Ms. Sharma?
Correct, Your Honor.
We'll proceed by default.
Yes, Judge. I would like to call Miss Patricia Spikes. Miss Spikes, how many children are we here for today?
One.
And how old is your daughter?
She's 9.
And who is her father?
Sterling McClendon Jr.
And how do you know he's the father?
Because I know he is, and we took a DNA.
And where was the DNA taken?
In the court downtown in Houston. I forgot the name of the street, but it's a testing place that's downtown where they do DNA tests and drug testing.
Okay, and this DNA testing was ordered as a part of your divorce from another person, correct?
Yes, ma'am.
And did the DNA exclude Mr. McClendon as the father?
No, he's the father.
Thank you. And are you asking the court to establish a legal relationship between Mr. McClendon and your daughter today?
No, it's okay because it's not a problem with that.
So you're asking the court to name Mr. McClendon as the father of the child?
Yes, ma'am.
And are you asking the court to order that you and Mr. McClendon are joint managing conservators?
It started breaking up. What'd you ask me?
Sorry, you're asking the court, or you believe it's in the best interest for you and Mr. McClendon to be joint conservators for your daughter, correct?
Joint?
Yes, what we talked about earlier, both parents having rights to the child and access to the child.
I mean, yeah, I know we talked about it earlier, but when I don't know when you're saying joint. I'm not for sure. I know what you were telling me as far as where he can attend and this and that at school.
Okay, ma'am, you're the one that's going to have primary custody of the child. You understand that?
Okay.
And you're a joint managing conservator, and your husband is a joint managing conservator, but you have the primary custody of the child. Is that all right with you?
Yes, sir. Okay.
All right.
And Ms. Spikes, how is your child covered under health insurance?
She receives Medicaid.
And do you understand the court is going to order you to maintain that insurance for your child?
Yes, ma'am.
And do you understand that the court is going to order the father, Mr. McClendon, to reimburse that at $57 a month beginning March 1?
Yes, ma'am.
And you agree that if the insurance doesn't pay for some of the expenses, that you will be responsible for half, and Mr. McClendon will be responsible for half?
Yes, ma'am.
And you understand that the court is going to order child support based on minimum wage at $217 a month beginning March 1, correct?
Yes, ma'am.
And you're asking the court to bill court costs to Mr. McClendon?
Yes, ma'am. You said bill him something? You said bill what now?
If there are court costs, who should pay for those?
Should Mr. McClendon pay for the court costs, ma'am?
You say, can he pay for it?
Should he be ordered to
Oh,
pay for it?
if someone needs to pay it, yeah, I would. He'd have to pay it right now.
All right.
Yeah.
And to confirm, you are not asking for any back support for the child, correct?
No, ma'am.
And you understand the state is not asking for any back medical or dental support, correct?
Yes, ma'am.
And have you reviewed this order and do you understand it, Ms. Spikes?
Yes, ma'am.
And are you asking the judge to approve it because it's in the best interest of your child?
Yes, ma'am.
Thank you, Judge. I pass this witness.
All right. The court will approve the order as submitted. Thank you.
Thank you, Judge. May we be excused?
Yes, ma'am.
Thank you. Ms. Spikes, you're free to go.
All right. Thank you all.
Thank
You're
you.
welcome.
Okay.
All right, this is cause number 2005-15326 in the interest of Miriam Martinez. All parties and witnesses, please unmute yourselves and raise your right hands to be sworn. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, ma'am, please state your name and your relationship to the child.
My name is Francisca Martinez. I am Miriam Martinez's mother.
All right, and representing the state,
Andrea Perard.
court will note that the non-custodial parent is Bobby Morgan Jr. Mr. Morgan was personally served on November 16, 2020 at 10:09 a.m. at 295 Interstate 45 North Holiday Unit in Huntsville, Walker County, Texas. And he's not filed an answer or made an appearance. Is that correct, Ms. Perard?
That's correct, Your Honor.
We'll proceed by default.
Thank you, Your Honor. And Your Honor, at this time, the state would offer an State's Exhibit 1, which is a true and correct copy of the financial record involved in this case. And I believe that Ms. Martinez has received her review as well.
Ms. Martinez, do you have any objection to me entering State's Exhibit 1 into evidence?
No objections.
All right, State's Exhibit 1 is admitted.
Thank you, Your Honor. And Your Honor, the state would also ask you to take judicial notice of the underlying order which the state is requesting to modify, which was signed on or about October 29th of 2010.
Okay, state will note. Take note of that.
Thank you, Your Honor. And Your Honor, this time the state would call Ms. Martinez. Ms. Martinez, Mr. Morgan is currently incarcerated in TDCJ. Is that correct?
Yes, ma'am.
Okay. And he has a parole eligible date that we are aware of July 28th of 2024. He could be out sooner or stay in longer. Is that your understanding?
Yes, ma'am.
Okay. And because he is currently incarcerated, it is deemed a material and substantial change, and therefore the state is proposing to modify his ongoing child support and medical support obligation since he is incarcerated. Or you understand that?
Yes, I guess.
Okay. And how is this child covered by insurance?
She's under my insurance through my job.
Okay, and we're going to order you to maintain that insurance through your employer. Unfortunately, Mr. Morgan will reimburse you at the cost of $0 beginning March 1st of 2022, and child support will also be set at $0 beginning March 1st of 2022, as well as dental. Is that your understanding and agreement?
I mean, I don't understand why it has to be set to $0 because he's locked up.
While you may not necessarily agree to you understand that that's what the law says because he's deemed to have no income at this time. Do you understand that?
Do y'all understand that he sexually raped my daughter?
Ma'am, do you understand that he has no income? He's incarcerated, and I can't make him pay child support while he's incarcerated. Do you understand that? You understand? That's what the law says. I'm not asking you to agree with it. asking you if you understand that that's what the law calls for. I know
Yeah,
you
the
don't.
law is messed up, but okay, yeah, that's fine.
All right.
I have no other choice.
Correct. Okay.
Thank you, Your Honor. And Ms. Martinez, you will, however, are still, we are confirming the child support arrears from the prior order. You do not lose those. And that's in the amount of $45,284.93 as of January 31st of 2022. And medical support arrears in the amount of $12,552.56 as of January 31st of 2022. Is that your understanding?
Yes.
And there is a non-disclosure finding in this case, therefore your address information is kept out of this court order. Is that correct?
Can you repeat that?
That there is a non-disclosure finding indicating that there has been issues of harm or abuse, and therefore your address is kept out of this court order, and you're in agreement to that and requesting that to continue, correct?
Yes, I guess. I'm pretty sure he has.
I pass. That concludes the order.
Ma'am,
Witness.
you don't want your address to be known. Is that correct by him?
Yes.
Okay, that's because there's been some abuse or some type of harassment or serious harm or injury, correct?
Yes.
Okay. All right, so we're not gonna disclose your address. Understood?
Yes.
Okay. Ms. Berard?
Nothing further. That completes the order, Your Honor. State, I pass the witness. State rests.
All right, well, you also understand, Ms. Martinez, that he's not gonna be ordered to pay that back child support, what he owes on child support and medical support, because he is incarcerated, but he does owe it. And when he gets out of jail, you can visit with the AG's office again, and they can pick up the child support and make him start paying again. Do you understand that that's the way it works?
Yeah.
Okay, court will approve the order submitted. Thank you.
Thank you, Your Honor. May we